Hi, everybody. Welcome back. Last time, we left the English Parliament in 1709, having just passed the Statute of 8 Anne, which created the first recognizable copyright in intellectual goods that we've seen in the law. And let me review what that copyright is. It is an exclusive right to copy an intellectual good, but only for a limited period. In the original legislation, I believe it was 28 years, after which the copyright reverts back to the public. So that anyone may use the intellectual good, just like Mr. Maestro claimed the right to use King's speech because it was in the public domain. So as you can see, this property right, copyright, is a rather peculiar right. It's very much unlike the natural rights of Locke, at least because obviously it has that limited duration. And as we'll see, there are other limitations on the use of copyrighted intellectual goods by the copyright owner and others that make copyright very different from ordinary Lockean natural rights, property rights that reflect that point of view. And copyright is something Bentham would have recognized and something that he would have applauded had he been alive earlier at the time. You'll recall what Bentham's idea of legislation was, that legislation had a point, and that the point of legislation was to maximize the sum of individual utilities, and that the state's responsibility was to articulate and assign property rights with that end in mind. So the rights and duties of copyright are to be created by law, Bentham would argue, not by God, and their purpose is not to protect anybody's rights for their own sake, as Locke suggested the purpose of government was, but copyrights are created to facilitate the maximization of social utility. And in order to do this, Bentham said, you had to think carefully about what the law would do, how it would work, and how it would balance the various interests that were involved in the subject of the legislation, so as actually to produce a piece of legislation that promotes the maximization of social welfare. And indeed, this is what the Copyright Act, the Statute of 8 Anne in 1709, did. And you can see this by a comparison of copyright, the rights that copyright awards to a copyright owner, and the rights that ordinary property right holders have in their property. Consider, for example, my watch, the piece of property we talked at right at the beginning of the course. I have perpetual monopoly ownership of that watch. What that means in more modern parlance is that I have a perpetual monopoly on the ownership of the right generally to possess the watch and to use it on my wrist to tell time. The monopoly part of the ownership means that I'm the only one that owns that watch. Other people own other watches, and people can buy watches of various sorts from large numbers of people. But if they want my particular watch, the only person they can buy it from is me because I'm the only one who owns that watch. So my ownership of the watch, in informal parlance, is a monopoly ownership. I'm the only one, and it's perpetual. I own this watch for the rest of time until I decide not to own it any longer, either by selling it to somebody else or by giving it to somebody else. My ownership of the watch doesn't expire, that is, at any particular time. Monopoly ownership of copyright, however, is, by the terms of the Statute of 8 Anne itself, limited in duration to some number of years, which means that the property owner, the copyright owner, has exclusive rights to use the intellectual good, but that those rights expire at some moment later in time, and that once they expire, they don't pass into the hands of any other private person, they pass into the hands of the public, so that no one can keep anyone else any longer from using that intellectual good for their own purposes. Similarly, my property right to ownership of my watch is exclusive. Again, I'm the only one who owns the watch, except for the other folks who own property rights that delimit what I can do with it. But in fact, the property rights that I do own in the watch are exclusive to me. I don't have to share those property rights at any moment with anybody unless I want to do so. Once again, compare that with the monopoly ownership granted by copyrights. As we'll see, monopoly ownership of intellectual goods, as granted by copyrights, is not exclusive. It doesn't mean that the owner of the copyright can exclude any other person from copying and using the good for their own purposes. We'll talk later about fair use, a very important topic in the subject of intellectual property. So the question is, why the difference between ordinary property rights on the one hand and copyrights on the other? From the start, the people who invented the notion of copyright and passed it into law saw copyright as responding to a different set of social objectives than those to which ordinary property rights were addressed. That is, that the problem of organizing exchange in intellectual goods was in fact a sui generis problem, that it had such important consequences given the nature of the free flow of information and the importance of information to any free or democratic society. Intellectual goods were seen to be a special kind of good, and so the people who organized copyright law tried to make the property rights that were associated with intellectual goods responsive to the particular social objectives that they saw characterizing the law of intellectual property. And those two objectives, which the copyright law has always tried to promote, are one, to provide incentives to create and publish intellectual goods. And of course, this means to allow the owners of intellectual goods, the copyright holders, to maintain some exclusivity in their ownership so that free riders, using whatever technology might be available to them, are not able to reach into the channel of exchange, extract the intellectual good without paying the copyright owner, and then secondarily publish the intellectual good itself. In order to do this, the property right has to be made exclusive so that it will provide the incentive for people to make the investment that's required to produce and publish intellectual goods. On the other hand, and I suppose this is the thing that the people in the 18th century thought distinguished intellectual goods from others, was that obviously we have a social interest in ensuring the widest possible distribution of intellectual goods. Intellectual goods inform and educate and entertain and enlighten and perform a crucially important role in any modern culture. Indeed, in any free culture, they're the lifeblood of the freedom of that culture. And therefore, it's important, obviously, to ensure the widest possible distribution of intellectual goods and not allow the ownership of those intellectual goods by property right holders to, in fact, inhibit or to inhibit more than is absolutely necessary the wide distribution of intellectual goods to the public. Copyright law, as it has evolved since 1709, has always assumed that these two objectives, providing incentives to create intellectual goods and ensuring the broadest distribution of them, are in tension with one another, and in some sense they obviously are. But the copyright law has been structured under the assumption that this tension does not exist in ordinary property rights, and that this difference is what justifies the differences in the two kinds of law. But the tension exists with every ordinary property right, as you can see by simply considering the right to something which is not intellectual property, but ordinary property, like a property right to wheat in the field. Here, the good in question is food. And if there's anything in the world that's as important as the free flow of ideas, it's that people get the food that keeps body and soul together and gets them through the day to put them in a situation where they're able to appreciate the consumption of ideas. So there's nothing more important to a society than to ensure the widest distribution of food to everybody in the community. Nonetheless, rights to food are protected by ordinary property rules. That is, the monopoly that's held by the owner of that wheat field is exclusive. Nobody's allowed to come and take the wheat from the field without his permission, and this is done so as to provide owners with the incentive to produce, as we saw in Hayek's thought experiment earlier in the course. The monopoly that the farmer holds to the wheat in the field is also perpetual. He doesn't stop owning it after some period of time, again, despite the need to distribute those goods to people in the widest possible way. And this means that we simply assume not that people, if they wait long enough, can have the good for free, but that people who want it or need it enough will be able to buy it, and that they will in fact do so. Now, limiting the duration of copyrights is obviously a utilitarian policy, and it weighs the costs of preserving incentives to produce intellectual goods against the benefits of the broad distribution of intellectual goods. But the second limitation on the exclusivity of property rights contained in copyright, what we'll call, and indeed what the law calls, fair use, is an even more striking instance of Bentham's influence. There's nothing like fair use in ordinary property rights. Only intellectual property rights, that is to say copyrights in particular, have a doctrine of fair use associated with them. The doctrine of fair use traditionally is said to date from a single important court case decided in the United States in Massachusetts in 1841. Back in those days, there weren't all that many judges around to listen to federal litigation, and so the justices of the Supreme Court of the United States, as they said, rode circuit. That is, each of the justices was assigned a particular portion of the country, and for some period in the year, those justices stepped down from their position as justices of the Supreme Court in Washington and traveled around their circuit, hearing federal cases and deciding them authoritatively. This was done in New England in 1841, and Justice Joseph Story of the United States Supreme Court was riding circuit in Massachusetts and heard a copyright case, in which, in his decision, he instituted the theory of fair use into American law. Citing the need for literary and scientific criticism and the broad distribution of intellectual goods to educate and enlighten the public, Story set out a theory that legalizes uncompensated use of intellectual goods under certain conditions. That is, fair use means that people can take the use of a copyrighted intellectual good away from the owner of the copyright while the copyright is still in force without consent or compensation to the owner of the copyright. But Story said this obvious violation of the copyright was limited to specific circumstances, and there were three of them. First, the use must have a public dimension. It can't be simply for your own convenience or your own entertainment or any other ordinary, even frivolous purpose to which one might put an intellectual good. The use that is claimed as fair must have that public dimension. It must be for an educational or a literary or a scientific or a critical purpose that somehow expanded human knowledge and transformed the use from purely private into public, producing benefits that would ultimately be realized by the larger society. Secondly, the entire work must not be copied. That is, the fair use copying can't serve as a complete substitute for the copyrighted work. What this meant was that scholars or critics could take notes on books that they had read, and that they could quote those books in scholarly articles or literary criticism of their own to illustrate their own articles or their own arguments about the work that they were criticizing or discussing. And this, of course, was very different than simply copying the entire copyrighted work wholesale, which would then pose a serious threat to publishers as secondary production or secondary publication. And this is suggested in the third of Story's conditions, and that is that the fair use must do only minimal economic harm to the copyright owner. No use, uncompensated, will do no harm, but some uses, like commercial uses where you steal somebody's intellectual good, publish it yourself, and try to profit from selling it at a lower price than the original publisher does, that produces enormous economic harm. But generally speaking, criticizing a book in print and quoting from it does not do any economic harm to the copyright owner because it doesn't substitute for purchasing the copyrighted work in the seller's host. This legalized theft of fair use, even limited in the way that Story limited it, is an obvious anomaly. This is clearly different from ordinary property rights. Imagine how a doctrine of fair use might work in the case of another good that we think is important to distribute widely and that we think produces benefits for very large numbers of people, and that good is milk. Milk is good for children, and healthy children are good for everyone, just in the same way that intellectual goods are good for all of us, informed people are good for everyone. Yet, despite this, we don't force farmers to give small amounts of milk free to dairies, nor do we force farmers or dairies to give small amounts of milk free to children, even if those amounts are small, and even if the cost to the farmers or the dairies of giving those small amounts to needy people would be very little. Social norms may encourage the milk company, the dairy, or the farmer to share some milk if people were actually in need, but there's no legal requirement that they do so, and there's certainly no doctrine that requires them to do so under any circumstances. Now, the old fair use, as it came to be called, the fair use that comes out of Justice Story's vision of fair use, cost publishers very little before World War I. And this is because the copying of entire works, which was still forbidden even under the fair use doctrine, for private use, was still generally done by hand and was much, much more costly than buying the book from the copyright owner. But then, around 1910, a new breaching technology appeared, handheld cameras, which were not like the small cameras that we're accustomed to now, but cameras that didn't necessarily have to be set up on a huge tripod and could in fact be used in a library to photograph documents page by page. When this new breaching technology appeared, it threatened publishers with unprecedented free riding. It's obviously much easier to take a picture of a page out of a book than to write out that page by hand, and now handheld cameras threaten to make it cheap enough to take a photograph of that page that it was worthwhile to photograph an entire work and not have to buy the work from the publisher. And the problems, the threat that this posed to publishing, led in 1935 to the Gentlemen's Agreement of that year, which was an informal agreement between a group of professional librarians representing readership and scholarship, and a group of publishers led by William W. Norton, whose name is now enshrined in the famous W. W. Norton Publishing Company. And in this informal pact, the librarians and the publishers agreed on guidelines for acceptable, uncompensated copying of entire works. And that agreement stipulated that single copies of entire works that were for educational, scholarly, scientific, or literary critical purposes would in fact be tolerated, even though they were in violation of the copyrights, because they were copies, and even though they didn't fall under the traditional categories of fair use, primarily because the entire work was being copied. The publishers agreed to this because even these photocopies made with those big handheld cameras were still expensive, they were still hard to produce, and there was not much of a danger that large numbers of people would photograph entire works rather than simply going down to the bookstore and purchasing that book for themselves. Moreover, the agreement made a virtue out of a necessity. After all, even if it were cheaper for some people to photograph a book than to buy it, to find out who that person was and then to take legal action against them, to punish them for what they had done so that they would pay compensation and perhaps deter others from doing so, that would be very, very complicated, especially for a publisher who's not in fact in the business of policing, they're in the business of publishing. So policing small-scale violations with the cameras would have been extraordinarily expensive, and so the publishers were able to look magnanimous by simply conceding the legitimacy of such copying simply because they knew it wouldn't hurt them too much. But by 1968, this agreement would come back to haunt the publishers as advances in breaching technology would make the gentleman's agreement of 1935 quite obsolete.